Okay, so the next thing that we're going to be looking at is contract formation. Contract formation. The rule: a contract requires mutual assent and consideration. Mutual assent requires an offer and an acceptance. Mutual assent is judged by an objective standard, not secret intent. A contract requires mutual assent and consideration. Mutual assent requires offer and acceptance. Mutual assent is judged by objective standards. So when we go to what an offer is, the rule for offer. Offer is a manifestation of present intent to contract with definite and certain terms communicated to the offeree. An offer is a manifestation of a present intent to contract with definite terms communicated to the offeree. An invitation to negotiate is not an offer. Essential terms include the party, the subject matter, the price, and the quantity. An offer is a manifestation of a present intent to contract with definite and certain terms communicated to the offeree. So, essential terms include parties, subject matter, price, and quantity. Let's look at termination of offer. The rule for termination of offer is an offer may be terminated by revocation, rejection, or counter offer, lapse of time, death or incapacity, destruction or illegality of the subject matter. So an offer can be terminated by revocation, rejection, or a counter offer, lapse of time, death or incapacity, destruction, or illegality of the subject matter. Revocation is effected upon receipt by the offeree. Revocation is effective upon receipt by the offeree. So now let's look at acceptance in common law. In common law, acceptance is an unequivocal assent to the terms of the offer. An unequivocal assent to the terms of the offer. Under the mirror image rule, acceptance must exactly match the offer. So acceptance is an unequivocal assent to the terms of the offer. Under the mirror image rule, acceptance must match the offer. Under the mailbox rule, acceptance is effective upon dispatch, while revocation is effective upon receipt. Under the mirror image rule, acceptance is effective. Under the mirror image rule, acceptance must exactly match the terms of the offer. The acceptance, the terms of the offer must equal the terms of the acceptance. Under the mailbox rule, acceptance is effective upon dispatch, while revocation is effective upon receipt. Acceptance is effective again upon dispatch. Acceptance is effective upon dispatch, while revocation is effective upon receipt. Now let's look at acceptance under the UCC. The rule is, under the UCC, acceptance may be by promise or by shipment of goods. Acceptance under the UCC is effective by either by promise or by shipment of goods. Shipment of non-confirming goods is an acceptance and breach. A shipment of non-confirming goods is an acceptance and a breach. Unless the seller gives notice of its accommodation, it should be an acceptance and a breach. Unless the seller gives notice of an accommodation. So, under the UCC, acceptance is by shipment or by promise, and the shipment of non-confirming goods would mean acceptance and breach, unless there is a notice of accommodation. If there's no notice of accommodation, then it is breach. Now let's move to Battle of the Forms under UCC 2-207. So, Battle of the Forms, the rule is a definite expression of acceptance forms a contract, even if it contains additional or different terms, unless acceptance is expressly conditional. The rule is a definite expression of acceptance forms a contract, even if it contains additional or different terms. A definite acceptance forms a contract, even if it contains additional or different terms. The offer limits acceptance, or there is a timely objective. A definite expression of acceptance forms a contract, even if it contains additional terms or different terms, unless acceptance is expressly conditional. A definite expression of acceptance forms a contract, even if it contains additional or different terms, unless acceptance is expressly conditional. That's the rule for Battle of Forms. A definite expression of acceptance forms a contract, even if it contains additional or different terms, unless acceptance is expressly conditional. Between merchants, additional terms become part of the contract unless they materially alter. So unless those terms materially alter, the offer limits acceptance, or there is a timely objection. So between merchants, additional terms become part of the contract unless the additional terms materially alter the contract, or the offer limits acceptance, the offer limits acceptance, or there is a timely objection. So let me take that again. Between merchants, additional terms becomes part of the contract unless they materially alter the offer limits acceptance or there is a timely objection. So we want to make sure that we get this. Between merchants, additional terms may become part of the contract. Additional terms may become part of the contract unless exception is those additional terms materially alter the contract, then they will not become part of the contract. Or the offer limits acceptance. If the offer expressly states that acceptance is limited to a certain term, then it would not become part of the contract if otherwise. And there is timely objection. So if an additional term is objected by the other party on time, then it will not form part of the contract, even if they are both merchants. All right, so let's move to consideration. Consideration. The rule for consideration is that consideration is a bargain for exchange of legal detriment or benefit. Consideration is a bargain for exchange of a legal detriment or benefit. Past consideration is not consideration. Pre-existing legal duty is not consideration. So that is past consideration. So a promise to perform a pre-existing legal duty is not consideration. Consideration requires a bargain for exchange. So a benefit has to be conferred, or an exchange of a legal detriment has to take place for consideration to be effective. So let's move to modification. Under modification, the rule is, at common law, contract modifications require new consideration. Rule: at common law, contract modification requires new consideration. Under the UCC, modification requires no consideration but must be made in good faith. Modification requires no consideration but must be made in good faith under the UCC. But remember, under the common law, there must be consideration for a modification to be effective. There must be some form of bargain for exchange under the common law for modification to be effective. Under the UCC, there is no requirement for bargain for exchange. And it must be done in good faith. So those two have to go together. No requirement for consideration, and it should be done in good faith. If it's not done in good faith, then modification is not going to be effective. All right, so let's move to promissory estoppel. Under promissory estoppel, the rule is that a promise is enforceable if there is a promise, a reasonable reliance, actual reliance, and injustice can only be avoided by enforcement. Those are the elements. One, there must be a promise. The promise induce a reasonable reliance. The reasonable reliance was actually actual reliance, and injustice was performed. And that injustice can only be avoided by enforcement. So remember, there are 4 elements for promissory estoppel. A promise is enforced if there is a promise, there's reasonable reliance, there's actual reliance, and injustice can only be avoided by enforcement. The remedy is generally reliance damages or reliance remedy. Promissory estoppel enforces promises without consideration. So promissory estoppel enforces promises without consideration. So for promissory estoppel to be effective, you don't need consideration. You just need reliance, actual reliance, and injustice that can only be cured by enforcement. So let's look at statute of frauds. Statute of frauds. The statute of frauds rule is that certain contracts must be in writing and signed by the party to be charged. Certain contracts must be in writing and signed by the parties to be charged. These include contract of marriage, suretyship, 1-year contracts, land, goods priced at $500 and above. So we're looking at marriage, suretyship, 1-year contracts, land, goods price $500 and above. For this type of contract, it must be in writing and signed by the parties. So whenever there is a fact pattern with a contract that concerns marriage, concerns suretyship, somebody taking over somebody's debt, or a contract that's going to last for 1 year and above, or a contract concerning land, or any contract concerning goods that are above $500. This must be in writing and it must be signed by both parties. So let's move to parole evidence rule. The parole evidence rule: when a writing is intended as a final expression, prior or contemporaneous agreement may not be used to contradict the writing. Let's take the rule again. When a writing is intended as a final expression, prior or contemporaneous agreements may not be used to contradict the writing. When a writing is intended as a final expression, prior or contemporaneous agreements may not be used to conflict the writing. So whatever is written that is final as a final expression stays in the contract as final. So you can't come in to bring new prior agreements or contemporaneous agreements to contradict the writing. No. What is final is final. Parole evidence cannot be contradicted. It is final. Parole evidence cannot contradict a final writing. So parole evidences is prior or contemporaneous agreements. Those prior or contemporaneous agreements are parole evidence. The rule is that they cannot come in to contradict a writing that is final. Okay, so breach. Let's look at breach. Breach and performance. A material breach excuses the non-breaching party's duty to perform. So for breach, the rule is a material breach excuses the non-breaching party, the non-breaching party's duty to perform. Substantial performance requires performance short of full but in good faith. A material breach excuses performance. A material breach excuses performance. What does that mean? When a material part of the contract has been breached, then performance cannot be expected. So it excuses performance. A substantial performance requires performance short of full but in good faith. So in a case where there's substantial performance, which means there is performance almost like it's only short of the full performance, and that's the short of part of it was done in good faith, then there is performance. Performance has been perfected. If there's substantial performance, which means performance almost short of full performance, then and it's done in good faith, then there is performance. So let's look at remedies. So remedies, the rule for remedies is expectation damages place the non-breaching party in the position they would have been in had the contract been performed. That's expectation damages. Expectation damages, which is the general damage for contracts, is expectation damages places the non-breaching party in a position in which they would have been had the contract not been performed. Damages must be foreseeable, 1, certain, 2, and mitigated. So let's take it again. For in contracts, damages, remedies, or expectation damages. Expectation damages are damages that place the non-breaching party in the position they would have been in had the contract not been performed, or had the contract been performed, sorry. So it places the non-breaching party in a position where they could have been had the contract been performed. Now, for there to be damage, the damage must be specific, it must be foreseeable, it must be certain, and it must be mitigated. So it should be foreseeable, certain, and mitigated. Specific performance is available while damages are inadequate, such as unique goods or line. So where damages are not adequate to cover the cost of of goods or land, then specific performance will be enforced. So let's repeat that. Damages, expectation damages, specific performance is available when damages are inadequate, such as unique goods or land. Expectation damages are the primary remedy in contracts. There are other damages like consequential, restitution, and others. But the main remedy in contract is expectation damages.